सत्येंद्र, मैं आपसे समझना चाहूँगा, व्हाट इज़ इंस्टीट्यूशनल आर्बिट्रेशन एंड व्हाट इज़ एड हॉक आर्बिट्रेशन?
देखिए, right now what is happening in India, there is mostly, rather I would be wrong if I'll quote the percentage, but it's mostly about every year is about ad hoc arbitration. Now, the difference institutional arbitration gets, like we have Delhi International Arbitration Center, we have Mumbai as well, and there are a couple of others also. Now, the different it has is that conventional or rather ad hoc arbitration system may have a slip of timeline. It may not be that professional. It may also have financial factors towards it. However, at the same time, when you look at the institutional arbitration, their way of operation is way more professional than the ad hoc one. There we have restricted timeline, and we start with an idea that this is the timeline. The case management is way more better with institutional arbitration than ad hoc arbitration, because ad hoc arbitration may, of course, parties are engaging themselves. Parties have mutually appointed, or let's say through section 11 proceeding, court has appointed one arbitrator. However, every second arbitration fails to conclude their own proceedings, or rather, forget about proceedings, tribunals don't even at times fail to even compel parties to complete pleadings within the prescribed timeline. At the first hearing, we call the preliminary hearing, the arbitrator is supposed to give out a certain timeline for parties to file their respective pleadings. And of course, considering the amount of claim, the arbitrator's fee is there. So there comes the financial aspect. Now, the moment pleading period goes out, or either of the party through some stating some affidavit that they could not file that pleading or they could not complete this, and they mutually end up deciding to extend the whole arbitration timeline. So it doesn't it ends up giving effect to this whole idea of arbitration. At the same time, when we look at the institutional arbitrations, of course these things matter there as well. However, at the same time, things are more professional. The case management is far better, and you have certain level of certainty. Yes, there also exists a level of certainty where you are sure that yes, your case, your arbitration matter will be handled very professionally.
गॉट इट। सत्येंद्र, क्या ये कहना गलत होगा कि इंस्टीट्यूशनल इन्वेस्टर्स के फ़ायदे तो हैं, लेकिन शायद इंडिया में आज बहुत ज़्यादा अभी भी एड हॉक आर्बिट्रेशन प्रेफर किया जाता है ओवर इंस्टीट्यूशनल आर्बिट्रेशन?
ये मैं बिल्कुल इसको कहना गलत नहीं मानूंगा, बिल्कुल सही है। उसकी वजहें भी हैं, क्योंकि जैसे आर्बिट्रेशन का एक मेन स्ट्रीम लिटिगेशन का पार्ट होना कई सालों का एवॉल्व प्रोसेस है।
राइट।
लिटिगेटर्स के लिए, लिटिगेंट्स के लिए, दोनों पार्टीज के लिए आर्बिट्रेशन को एज अ टूल एडॉप्ट करना एक अच्छा खासा सालों का इन्वेस्टमेंट है।
राइट।
जिसमें कोर्ट्स का भी कंट्रीब्यूशन है फॉर इशूइंग सर्टेन क्लैरिफिकेशन, फॉर letting these executive bodies or to legislature to understand and issue amendments towards it. ये एक इवॉल्व प्रोसेस में इसलिए कह रहा हूं क्योंकि इसने अपना समय लिया है और पार्टीज ने समझा है कि हाँ, आर्बिट्रेशन भी एक टूल हो सकता है मेरे डिस्प्यूट को रिजॉल्व कराने का। अब वही बात आती है कि इंस्टीट्यूशनल आर्बिट्रेशन का आइडिया पार्टीज कितना एंटरटेन करती हैं, लिटिगेटर्स कितना एंटरटेन करते हैं या लिटिगेंट्स कितना एंटरटेन करते हैं, वो अपने उनके इंटरेस्ट पे भी डिपेंड करता है। हाँ, ग्रेजुअली वी आर पिकिंग इट दैट अप, हाउएवर, बट देयर इज अ लॉन्ग वे टू टेक अप।